in the interest of public trust, do you think it should be made as public and available as possible, especially to exonerate people perhaps falsely accused?
I think there should be as much transparency as possible, but it comes in a very strict legal setting. During the Clinton administration, the Hill and the president let the old Independent Counsel Act lapse. They replaced it with a Special Counsel Act in 1999, and that is much more rigorous in terms of the process. The process is pretty simple. The report gets submitted confidentially. A report gets submitted confidentially. It could be 5 pages, it could be 200, but it goes confidentially to the Attorney General. The Attorney General is only obligated to communicate the fact that he's received the report, and if there has been an instance where the Justice Department took or refused to permit the special counsel to take an action that he wanted to take, then the Attorney General has to report that to Congress as well and explain. There's no obligation to make the report public. There is a public interest consideration, but it doesn't generate any rights for either Congress or individuals in court. It can't be litigated because there are no rights created out of that act. So Congress could subpoena it. It would be subject to executive privilege claims should the administration want to do it. My guess is that whatever is presented by the Justice Department will be unsatisfactory to certainly the Democrats, likely the press, and there'll be constant pressure to do it. There's also the possibility of leaks.
All of it out there is one extreme, and I think most reasonable people would agree that, okay, there might be certain things that should be redacted from that. But is it, at a time, the session's called Truth on Trial, lacking transparency with truth so debatable, so fungible these days, isn't it in the national interest to try and get as much out as possible? And Suzanne and Richard, I'll let you guys weigh in on this in a moment.
But, well, there's some difficulty with that, which is, I've read recently people saying, well, you can go the Leon Jaworski route or the Ken Starr route and, have a short report or a, multi-volume treatise. But the reality is there are legal considerations, and there are 2 statutes that, in particular, that directly affect what can be released. One involves grand jury secrecy. One involves, the discretion of the Attorney General in connection with however he wants to summarize or put something out. Would he do the report with redactions? I doubt that. I think it'd be more likely to be a Justice Department summary of the findings if he did that. But you just don't know, and so and this gets into the issue of people complaining about Starr and the ability to put that report out there and all the passion that was ginned up at that stage of the game that forced the new statute, which was designed to pull back on that, and that's the
because no granular detail was left uncovered in the Starr report.
Right, and Bob has done. Bob Mueller has done effective job, I believe, in the indictments and sentencing memos of telling the story that he has. So it's not necessarily that there aren't a lot of facts already out there. It's just on everybody's collusion meter, they want to see where things land, and I'm not sure that everybody's going to be satisfied on that.
But I see on TV Michael Avenatti, Rudy Giuliani, Lanny Davis. They don't seem to me to be acting as attorneys in that role, but as public relations spokespeople. And this also happens within corporations. So what are the implications of, quote, lawyers becoming PR spokespeople? And does that have an issue with, does that mess with attorney-client privilege? What can they say? What should they say? What shouldn't they? Where do they sort of draw that line?
There are very real dangers when you do that, as Lanny Davis found out recently when he misled the country with regard to certain facts that Cohen would allegedly testify to, and he had to walk it back. Clearly didn't have his client's authority to say it. Turned out not to be true. when he makes statements like that, he's acting as an agent, so it could be used against Cohen. I think that you see lawyers get out, as was said well in the earlier panel, that the day of letting the story come to you is over. You got to get out and manage the story. You've got to, and you need to do it very professionally. Try to limit the facts, make it clear what the process is, and be accurate. And one of the most important things, as the governor said, and as is highlighted by the Virginia situation, is you have to master the facts immediately before you talk. Because putting out a palliative, that's not going to help you. You need to be able to make a forceful statement that's factual and will stand up under scrutiny. You can't have a changing story or you bury yourself.
What do you have a value that everybody has something of value that's going to be exfiltrated at some point or has. So legal needs to be involved there.
Yeah, I always tell clients that the first 48 hours are essential because that is where 90% of the mistakes in case management happen. And Suzanne, I know from her compliance background, has seen this, that there will be 20 conversations that don't involve legal, all of which are subject to a lack of privilege, and people would have to testify about it. So getting legal in immediately to preserve the privilege and to ensure that nobody screws anything up and the documents are preserved and that the company acts honorably. Whatever's happened in the past, that they act honorably from that, the first sign of an investigation forward. I mean, you can't really prepare for something like the Robert Kraft thing. You need to go straight to well-trained people and hope they do their best work, because it's not something that you plan for. But the teamwork is essential. People have been trying to get this formula right for 2 decades. People move too fast sometimes. People move too slow. That's why you have to have the red team drills. Figure that out. And facts rule. Facts rule. I mean, so take the Justice Smollett event. People who moved in too fast and were too judgmental, obviously have some egg on their face. It's understandable. It's not a reason to crucify anybody, but getting your facts right and maybe waiting a day for the police to
and we'll get to that with the news cycle with the next group.
And the same thing on a Me Too, a Les Moonves type thing. You have to. It's something where people need to understand, even if you don't have an answer, you're taking it seriously.
Great. And